Terrell. This is Robert, and I just wanted to go through and do a little bit of research with you. Show you how we did our research, and we kind of initially uh, brainstormed, did some brain mapping, and trying to figure out some really good Boolean search terms. And essentially, what I did initially is I did like what everybody else would do when I'm looking for a topic. I actually Googled it, as funny as that may sound. And my search term within Google was if a firefighter is injured in my business responding to an emergency, could I be held liable? And I thought this was interesting because it brought up a lot of different websites. I didn't think this would even be that big of a topic. And talks about workers' compensation issues. And really looking through this, I don't want to spend too much time on this, but with plaintiffmagazine.com, it says recent issues, and the article is protecting first responders from abuse of the firefighters rule. And I've never heard this term, so I kind of opened this up and I was reading through it. And basically, this mostly has to do with law in California. So it's not binding law for Tennessee. Um, uh, but I liked the fact that it gives you really the firefighters rule generally. This applies basically in almost every state within the U.S. And I found this actually article very interesting. It talks about public policy, and the policy being that in most states, a firefighter can't recover for injury from a business. Basically, if there's some type of inherent danger that the owner knows about, um, sometimes they can't recover for that. The different circumstances behind that. Now, California has its own set of laws pertaining to that, so I don't believe it wouldn't be binding law in Tennessee. It just kind of wanted to give you an idea of where I got the reference to what I'll be using a lot in my search terms is the firefighters rule. So that came from that. And let me go ahead and just get to Westlaw here. We can kind of go through some of my search terms, and I'll talk about the cases that we selected for our binding law within Tennessee. And basically, the first search term that we did here was firefighter. And basically, we in our uh, kind of brain mapping and brainstorming, we came up with some different terms like third-party action, personal injury action, negligence, workers' compensation. But really, I felt like this firefighters rule would really apply to our search terms within Westlaw because this deals directly with firefighters getting hurt in the course of their normal job as a firefighter. We all know that, of course, this talks about the inherent dangers in their job and so forth. So, what really the first case or first search I did was injury. So firefighters rule in injury, and we saw kind of what came up with that, and looked through it, and actually we got our two cases actually here, Jamison Ulrich and Carson B. Hedrick, which actually we uh, reference. And basically what I could do is just open up the case. It's in Tennessee here. Uh, this was decided by the Court of Appeals of Tennessee, and this was in 2006. So a little bit of background. This is an animal control officer who was attacked by a dog during the course of his job. He was bitten by the dog, and I'm sorry, I'm a little bit tired apparently. He was bitten by that dog in the course of his job, and they applied the police officers and policemen and firefighters rules in this case, and they did find that it it applied to police officers and uh, firefighters, but it didn't necessarily apply to the animal control officer, uh, and in this particular case. So, let's see, there was, here we go, okay. This was what I was specifically looking for under negligence. And it says the policemen and firemen will preclude firefighters and police officers from recovering damages for injuries arising out of risk peculiar to their employment. Meaning that we know that a policeman and a fireman's job is inherently dangerous. There is a high risk of injury with those two professions versus someone working at retail establishment, or there was a possibility of different jobs that could be sustained, injuries that could be sustained within those career fields. And so we did go ahead and pick this since it does deal with negligence. We're talking about negligence within our case, and it directly speaks to our case that would that the fireman's job precludes him from recovering damages for injuries arising out of his employment. And we know that he was responding, he was on duty, he was an invitee of the store owner into the business based on an emergency call placed by the store owner to have him come in and investigate a carbon monoxide alarm that was received at his business. He fell through a weak floorboard and was injured during that subsequent investigation. So I felt that that was a really good, strong, this would be a strong case to work in favor of our particular case. And if we go to Carson v. Hedrick here, and in this, oh, okay. And under the negligence here, it says, under exception to policemen and firemen's rule, a citizen has duty to refrain from, either by action or inaction, intentionally, maliciously, or recklessly causing injury to a police officer responding to citizens' call for assistance. The whole otherwise would be to stretch beyond its logical and justifiable terms that policy considers supporting the rule. Not what it was. Oh, I'm sorry. Here we go. I'm looking at the wrong one, of course. And under the policeman and fireman's rule, citizens owe no duty of reasonable care to officers responding to that citizens call for assistance. Such rule is based on public policy consideration. The citizen should be encouraged to summon aid from police officers, regardless of the citizen's negligence, and should be assured that compensation for injuries suffered by police, or in this case would be a firefighter, in the line of duty would be borne by the public as a whole, meaning that the public insures the police officer and firefighter against their injury, and that should really be sufficient to compensate that firefighter or policeman for his injuries without him going above and beyond, or outside of no negligence on a store owner or property owner's part, if to allow him to recover additional damages, essentially, or additional monies for damage that he's already been compensated for by the city or the public, is my understanding. And Sherelle brought up a great idea of looking up for looking for the elements of negligence. Well, we need to discuss that in our research, and she was able actually to find a case, um, and we narrowed the search term down to property owner and liable for injuries, and that brings up I guess it says my oh oops, I'm sorry. I am very tired and I apparently can't type. Let's see if this will work. And it is actually the Parker-D Holiday Hospitality Franchising Inc. was the case that we chose also. And in this case, it was a hotel patron. His wife was injured by the work of a contractor. And it really speaks to this because under negligence, we know this is a negligence case. Um, and is let's see if I can find what. Oh, here we go. Under negligence elements, uh, and what Sherelle was able to find is this under T Site 13 negligence. It says persons seeking to prevail against a property owner on a premises liability claim must prove the elements of a negligence claim. In addition, must prove either that the condition was caused or created by the owner, operator, or his agent, or if the condition was created by someone other than the owner, operator, or his agent, that the owner or operator had actual construction notice that the condition existed prior to the accident. And this is a key element in proving negligence because you have to show that the property owner was aware of the condition and let it go on, and that would clearly show his negligence, and that uh, he would have a duty of care owed by the defendant to the plaintiff. Those elements would be and the conduct by the defendant falling below the standard of care amounting to a breach of duty to the, in this case would be the firefighter, an injury or loss by the firefighter, which obviously he broke his leg. Causation in fact, meaning, did he, did the store owner bring about the condition that caused the firefighter to become injured, or in this case, to break his leg? And was that the proximate or legal cause of the firefighter's injury? And I think that basically, uh, uh, these are great cases that me and Sherelle were able to find. Now, Jennifer did elaborate a little bit on her research, which I think is great, and it really coincides with what me and Sherelle found. And I'm going to go ahead and play her uh, video for you.
Hi, this is Jennifer, and this is my research part of our presentation today. Um, you will recall we are Group 1 and our research topic is premises liability. We're researching, as you've been told in our presentation, if the fireman enters a business to investigate a carbon monoxide alarm. Um, is the owner liable for injury that the fireman sustained as a result of a weak floorboard? So I went to Westlaw, of course, and I'm logged into Westlaw, and I am in Tennessee because that's where I want to be, and because I know that premises liability is what I want to be looking for, and I want those words to always be together, I use the quotation marks to take a first look at just exactly what comes up when you pull up premises liability. And of course, there's 568 cases that relate in Tennessee just to premises liability. So I know that's more than what I want to go through. So I go back and look at my question again, thinking about what my issues are. And really my issue is not just premises liability, but premises liability as it relates to a fireman specifically. So I want to see if I can find a case that relates specifically to a fireman. And I've used the asterisk here because I don't know if it's going to be fireman or fireman. And I checked that out, and I'm down to 4 cases, which is great. And I really liked this Buckeye Cotton Oil Company case because it said that it all depended on on other circumstances of whether my fireman could file a case. And I thought, oh yeah, it depends. That always is good. But then I saw the red flag and looked at it and found that this case was abandoned by this Hudson v. Gayton case. So I thought I best, and that was in 1984, and so I pulled up the Hudson v. Gayton case and read through it, and it did talk about Buckeye in here, but the very first thing is that it says in the head notes that it rejects the status distinctions that Buckeye plainly set forth of whether the fireman was an invitee or a licensee. So those common law classifications were no longer a determinative in whether the person could sue, the fireman could sue or not. So I lost my really good case that I really liked. So I had to go back and to look at some research, look at my cases again. And I wanted to bring to your attention while I was here that Buckeye case is a 1922 case. So while I'm looking here, I see something about a fireman's rule in this first case. So I went to this first case. My system's running a little slow this morning, and so I apologize for that. And I want to see what this fireman's rule is, because it sounds pretty interesting, considering I'm related to my case as a fireman. And it talks about that a citizen owes no duty of reasonable care to police officers. So I clicked on the professional rescuers or firefighters rule, and there are 6 cases listed here. And so I went to this Bridges case, and the Bridges case is a reported case in 952 Southwest 2nd at 841. It is a Tennessee Court of Appeals case in the Western Section in Jackson. And this case goes on to say that this case actually, the widow of a firefighter said that was claiming that all the rules weren't followed, or all the procedures weren't followed by the firemen, or by the fire department, or by the chief or the team leaders, and thus her husband got killed. But the case ruled that under the firefighters rule, that policemen and firemen cannot make a claim against a property owner or a landowner if they're there in their line of duty or under the role of what their job is, and that the firefighters rule expects the community, because they're a public servant, to take any liability on that fireman's behalf. So in this Bridges versus City of Memphis case, the Court of Appeals overturned the lower court's overturned the lower court's opinion, and denied the claim. And I'll quit going back and forth in a minute. But the case was reversed and remanded back to the lower court to finalize it based on the policeman's or the fireman's rule that they could not make a claim. So that's my part of the presentation. Sorry to be so long. Thanks for listening.
All right, everyone. So that is our presentation. And as you probably can tell from the video, we both are all agreed that the firefighter in this case would not be able to prevail in a cause of action against a store owner for injury sustained while reporting to a emergency call at the business. So we don't believe that he would be able to prevail due to public policy and the fireman's rule and firefighters rule, excuse me. So that is our presentation. I hope you enjoyed it, and take care.